expected to survive. Authorities are investigating a bomb threat found aboard a Chicago-bound flight from Rome. The United flight was forced to land in Ireland after the flight crew was alerted to a threat written in the bathroom. States will be allowed to purge inactive voters. NBC Justice correspondent Pete Williams says the Supreme Court ruled in favor of Ohio today in a case that could have broad implications across the United States.
Other states were watching this decision to see how it would come out, and they may decide to copy what Ohio does here.
The case involved the removal of people from voter rolls for not casting ballots in elections for 2 years and for not returning warning notices. One of New Jersey's most iconic performers is the talk of the 2018 Tony Awards. Bruce Springsteen last night was awarded a special Tony for the success of his massive hit show, Springsteen on Broadway. You're listening to the latest from NBC News Radio.
If you or a loved one was seriously injured in an accident with a semi-truck or an 18-wheeler truck, you need to act fast. I'm attorney Daniel Rudbari. I know how to fight truck companies. Call me 800-325-1454 for your free consultation. 800-325-1454. Truck accident cases are different than an auto versus auto accident. There are so many more issues involved when dealing with a truck accident case. There are federal regulations and state regulations, several different companies that may be involved. I can immediately gather the evidence, get you the medical care you need with no deductible and no copay to you, and get you the compensation and the money you deserve for your injuries. And if there's no recovery, there's no fees charged to you. I'm attorney Daniel Rudbari. I know how to fight truck companies. Call me 800-325-1454 for your free consultation. 800-325-1454.
KCAA.
And now, it's For the People with Judge Herb Dodell.
Well, good afternoon, ladies and gentlemen, and welcome back to For the People. We ask Gary every now and again, why is the show called For the People, Gary?
It's because it's for you.
No, it's for the people.
Well, you didn't let me finish it up. It's for you, the people.
You're absolutely right.
You jumped the gun.
Yeah, well, after last week, it was certainly an interesting show last week with Roger Stone.
It was a great show.
And I'm going to follow up with some of that because I thought about it and I've listened to it a couple of times. And I thought it was pretty interesting.
It was.
This guy has some interesting concepts. His whole conspiracy theory is going to be based on what's called circumstantial evidence. So the second part of the show today, I'm going to talk about circumstantial evidence and give you some real examples. One is a real criminal case, and the other, I made up some facts, which I thought would be interesting to present to the people so they get a real example of the difference between direct and circumstantial evidence.
Cool.
We already talked about what a conspiracy is, but most of the time conspiracies are based on circumstantial evidence. And that, if you think about what Roger Stone said last week and the allegations that he was making, it really is circumstantial evidence. And the facts may not be supported by the real evidence.
Well, look what happened with the report, the DOJ report on Comey and the FBI and Loretta Lynch. It sort of hammered all of them. I don't know if that was circumstantial evidence or not, but
no, that's direct evidence. That's
okay.
That's what you see. That's what you say. That's what you do. That's what makes it direct.
All right.
Circumstantial evidence is basically a fact, an alleged fact, upon which an inference could be based. You know, you'll see it in the example that I'm going to give. It was a very interesting case. We've talked about that case previously. And you'll remember it when I start to go over it again.
I'm sure I will, Judge.
Oh, you will. But you didn't remember I got locked up in Chino.
Yeah. Well, because you just talked about being locked up in Chino. You didn't do the breakdown of the case and the whole dynamics of it. You just said you were locked up in Chino and
I
freaked out.
was.
All right. Well,
I wouldn't say I was freaked out. I was well protected.
oh, whatever.
I was between the
You
bars.
were scared.
I was more scared when they let me out. And I had to walk down the hall, and I see all these guys with the combs in the back pocket. You know what I'm saying?
Yeah,
I'm walking down it with a briefcase and wearing a suit. What was my chances there? But it's a great story, and we're going to talk about this criminal case, which had a very, very unique, very unique ending. But before we go there, we're very pleased to say that we have a guest in the studio.
Yes,
today.
we do.
And it kind of fits in with some of the things that we've been talking about the last weeks dealing with criminal stuff. Although I'm sure he does stuff in civil cases too.
I'm sure.
His name is Scott Ross, and he has the unique experience of having been the private investigator on the Cosby case.
Yes.
I'm sure he's not going to have too much to say about that, because the matter is on appeal, and you don't want to do anything that might jeopardize that. But he was also the private investigator on Robert Blake and on Michael Jackson. So we're going to just ask what private investigators do. We see him, he used to have these great TV shows, still running them in syndication.
Rockford Files.
Mike Hammer.
Conrad.
Whatever. All
Mannix.
Mannix, yes.
Remember that?
Yes, I do.
I loved all those shows.
He was a good guy.
He was.
I met him a couple times.
Did
he was
you?
a good guy.
What was his name?
I can't remember.
Mike Connors.
Mike Connors. That's right.
Exactly
Mike Connors. That's right.
So anyway, Scott Ross is here today, and
Beretta.
He's going to tell us a little bit about what a private investigator does, so that we have a better understanding of how important they are in the ultimate outcome of any case. And if you are a criminal defendant, it's not exactly a luxury, but it's almost a necessity in many cases, because you need to get information, and lawyers don't generally do that. And in my opinion, which I've expressed on the show, I think after the Cosby result, was the fact that these other women had testified made an enormous difference, because that's basically circumstantial evidence. Even though it isn't called that, it's called prior acts. Many times, those prior acts do not get into evidence because they're pretty prejudicial to a defendant. But sometimes they do.
Yeah.
And they did this time, and I think that made the difference between the first case and the one where he got convicted. So feel free, Scott, to tell us a little bit about what you do and how you do it. And if you want to talk a little bit about Cosby, I'll ask you some leading questions.
Sure. Well, first things first, good afternoon, Judge, and thank you for having me.
By the way, I just want to, one of the things that we do here, we've been doing this forever, is whenever I use any legal terminology, I explain what it means in layman's terms. Very important.
So I can understand, Scott.
Okay.
He's going to be taking the bar next year. Gary's gotten a real education here.
I told you I came close to becoming a lawyer.
And in California, you don't have to go to law school to take the bar. You
That's
can take
true.
a specific program.
I don't even think you have to take the program. I think you just need to take. You don't even have to go to. I think they're called registered law schools, or I don't know what the term is.
Yeah, I'm not
But
sure.
you don't even. You could take it online, I think. these
Really?
days. Yeah.
Wow. Maybe I'll do it.
Not taking the bar online, but you can take classes online, as long as you get certified that you've taken, all of those classes. But I just used a legal term called leading question. So what is a leading question? A leading question is one that has the answer already built into it.
Okay.
Isn't it true that you were walking down a Fifth Avenue?
No.
It's a leading question.
Okay.
And you're not allowed to ask leading questions except if you're cross-examining. Then you can use leading questions, and that's what you do. When you do a really good cross-examination, and I'm going to get to Scott in a minute. I got distracted here.
That's all right. We got an hour.
But the fact of the matter is, the best cross-examination is only leading questions. Isn't it true that he's your son, or whatever it is that comes up? You only ask leading questions. You can't get hurt with a leading question.
And questions that you already know the answer to, correct?
Of course, you don't ask questions you don't know the answers to,
I got you.
unless you don't care about the answer. Sometimes you ask a question, you don't care what the answer is. You don't want to make an impression or get a response from it. But leading questions for all of you out there who are thinking about studying law and want to get into litigation is the way you do it if you're cross-examining, and as much as you can get away with when you're doing your direct examination. Direct examination is when you're asking questions of witnesses, and the opposition asks questions. It's called cross-examination. So with that in mind, Scott, tell us a little bit about you.
About me?
Yeah, what do you do?
Tell about me. I do as little as possible.
That's why you're here.
You know, a couple things that you mentioned already that are interesting. One of the things I wanted to comment on, you talk about having the answer to your question, and then you ask, what does a private investigator do? I supply my attorney, who's actually the client, I supply the client with the answer to those questions so that when they do ask the questions under oath on the stand, when it becomes evidence, that they do have that answer. So that's basically, if you will, that's sort of a start of the characterization of the work that a private investigator does. The other thing you had previously mentioned, conspiracy, and one of the reasons that conspiracies are used by the prosecution is because in a conspiracy you can bring in hearsay evidence. You have to get into that as well. But conspiracies enable witnesses to talk about hearsay, what somebody has told them, what they've overheard. And again, this is a classic example going back to Cosby, where the prior bad act witnesses were able to discuss hearsay evidence, things somebody else told them, things that they heard from somebody else. And again, all of that has to do with the conspiracy theory, and the prior bad acts fell under that sort of quasi-conspiracy issue. That this is an ongoing issue with Mr. Cosby, and therefore it's, for lack of a better term, a conspiracy.
How did they get it in?
Well, in this particular case, and I have to apologize, I don't know Philadelphia, or excuse me, Pennsylvania law, but the judge allowed it, and it was in this particular trial, it almost seemed it was discretionary, and the judge allowed it.
It probably is a discretionary ruling.
Yeah.
In fact, we mentioned last week or the week before that when you have a discretionary ruling, most of the time it sticks on appeal unless you can show an abuse of discretion by the judge. We'll talk more about that right after the break. And the book is called
From the Trench to the Bench. You can get it on Amazon.com. And Scott Ross is starting his new show, All Things PI, a week from Thursday, June 21st, right here, 9 a.m. on KCAA Radio.
Sounds great.
Cool. We'll be back after this.
10:50 a.m. KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Welcome back. I had a few minutes to talk with Scott, and we were talking about the Cosby case, and we had started to talk about abuse of discretion and how infrequent it is that courts overturn decisions made on discretionary calls. So you were telling me about the jury and...
Well, in this particular matter, the jury basically released a statement, what they consider to be a joint statement. It was put together by a professional, indicating that they didn't use any of the information from the prior bad act witnesses, that it was solely based on Mr. Cosby's own words from his deposition. And the fly in that ointment, if you will, or the appealable issue in that is that the deposition that he gave was by the word of Bruce Castor, who was the prior DA before Mr. Steele, who indicated that he would not prosecute Mr. Cosby, that Mr. Cosby could deal with it at a civil level, and that the civil level could only go forward if he was guaranteed no prosecution. But the problem is he didn't put it in writing. Apparently in Pennsylvania, something of that nature has to be put in writing. And so Castor's word wasn't supported, as it were. And when Kevin Steele ran against Castor for DA, he used that campaign as his platform, his sole intent to prosecute Mr. Cosby, that Mr. Cosby would not be getting away with this. That in and of itself is a little bizarro, but whatever. The federal judge, some federal judge, totally unrelated to Cosby's anything, released the deposition, ordered it to be released. And
why?
No idea. Didn't like Cosby. And the Court of Appeals actually said, you can't do that. Said, you overstepped your bounds. You don't have the authority. They reversed it, and then they sort of grabbed it. But by then it was out. And Steele took that and used that deposition, again, against him, violating his Fifth Amendment privilege. So again, all of these issues are appealable.
That sounds like a decent argument, actually.
We had an attorney present during the trial. Her name is Becky James. She's actually out here in Calabasas. And Becky's sole purpose of being there, she's an appellate attorney. So she was at council table with Tom Mesereau and Kathleen Bliss, and her sole purpose of being there was as an appellate attorney. She's currently working on the appeal.
I had never heard that before, because I always wondered, if I was Cosby's lawyer at the time of his deposition, I never would have allowed him to say anything even close to what they used to convict him. For him to admit that he had given these people quaaludes in the past and whatever was a killer.
Well, even talking to the police, you should have never had a conversation with law enforcement. Tom and I both represent right now Danny Masterson, the kid from that 70s show. And he's lost his job with Netflix, but the police repeatedly have asked to interview him regarding these allegations, and Tom's response is no. We're not even going to give you an interview, period.
Well, that makes sense. As I did criminal defense for a long time, having come out of the DA's office, and the smartest thing you can do as a defense lawyer is tell your client to keep him or her mouth shut.
Right.
Because they only can bury themselves. In fact, when we talked about putting clients on in criminal cases, I rarely put them on the stand. I did. We used a couple of examples, actually. And sometimes you have no choice.
Exactly.
And no choice.
And the problem is when you have those people where you have no choice, and I've had several of them that are too intelligent for their own good, and several of these people want to tell their story. And correct me if I'm wrong, this is where everything goes south, because the DAs are a lot smarter than they are, but they don't accept that. And when they get up there and try and tell their story, they have sort of a set pattern of how they want to tell it. I got in the car, I drove here, I had this for lunch, I stopped, I got gas, blah, blah, blah. And once that gets out of sequence and you start to sort of reverse some of those questions, they get frustrated because they want to tell their story. And I've had two cases, both out of Torrance, actually, back to back, and both of them went south because both of the witnesses insisted, or both of the defendants insisted on testifying. One of them, there was no choice. The other one, he didn't have to, but he chose to.
I was a DA in Torrance, as a matter of fact.
Oh, this is in front of Judge Arnold, Mark Arnold, great guy.
Oh, yeah, I know him. Yeah. He's a good guy.
Former Los Angeles police officer, former DA turned judge. Yeah,
happens.
Guy. Yeah, great guy. In fact, actually, Judge Arnold, I did the LAPD Rampart case, and Judge Arnold actually, at the time he became a sitting judge, was one of our witnesses that we had to pull in. If you remember the Rampart case in the late 90s, we had to pull the judge in because he was a DA and involved with Ray Perez at one point.
Well, it goes back to the question of putting your clients on. And basically what happened in your Cosby case is he testified without testifying.
Well, and we had the same thing with Jackson, but it was a different scenario where Michael Jackson, they used the Martin Bashir video in Michael Jackson as one of the first things that they introduced. In fact, the prosecution first put on Martin Bashir. And in that video, you see the kid come over and jump on Michael and say, I slept in the same room as him, ignoring the fact that Michael's room was 3,000 square feet. Just the bedroom, forget the house, just the bedroom was 3,000 square feet. And they used that, and Michael was smart enough to have had somebody videotape the entire interview. So ultimately what happened was we, at the end of it, in the defense posture, we were able to play the entire, whatever it was, 2.5-hour video that was unedited because Bashir was playing the edited video.
Well, trying cases whether they're civil or criminal cases, requires a lot of real good strategizing. And it's very important that you be prepared.
Yeah.
So people like you make all the difference in the world because you do what you do, and it makes us so much more prepared to handle cross-examination and even direct examination if you're going to call your client as a witness or with a witness in general. Forget about the client.
And one of the other things you'd ask specifically, what in a criminal case, that the investigator, one of the most important roles that I've always played is I'm that buffer zone between the attorney and the client. So if the client's done something, I don't have the same obligation that the attorney does. If the client's going to get up there and they're going to lie, they're going to do something, and if I don't want the attorney to have that information so that they're not suborning perjury, I mean, I just eliminate the information, so to speak. Tell the client you can't discuss this, you can't discuss that, and certain things just don't get turned over to the attorney. So I'm sort of that buffer zone. If a client has a question, wants to ask about something incredibly stupid, and it happens all the time, again, I sort of insert myself into that situation so that they don't have to do that.
You know, so many people have asked me over the years, if you know your client did it, how can you represent them like that and put them on the stand?
Money?
The answer,
No.
well, the answer really is, I never asked the client if they did it.
Right.
Because if I was going to call him as a witness, him or her as a witness, I couldn't ask them on the stand, did you do it, which you like to do if you can. If you already know the answer is, yeah, he did it. And that's an ethical issue, and it's disciplinary if you do it. Not that you ever would, but you don't do that. You don't put them on. But it seems to me I don't know enough about the record that you have. You certainly are eager about it and convinced about it. There may be some good constitutional issues here. I told a story not too long ago of not putting a client on because I couldn't put him on. He would have been beyond awful, beyond awful. There was no description for this guy. He loved to talk, and
Right.
you couldn't stop him.
Right.
There was nothing you could do about it. And the fact is that he was an insurance fraud claim, and he had given an examination under oath to the insurance company, which they're entitled to take after you make a claim. And it was before I was representing him, because I never would have let him do it. And during the course of his examination under oath, he made some serious admissions. I didn't call him as a witness. I couldn't. But they got all of that in
They still get to
because
use
it's
it, sure.
considered to be an admission, which is an exception, by the way, ladies and gentlemen, to the hearsay rule.
Plus it's testimony.
And
because
it's actual testimony.
Right.
So the bottom line is you have to be very careful about what you ask the clients, number one.
But it's a double-edged sword, isn't it? Because again, if the insurance policy, if you're trying to collect on a policy and the policy requires the examination under oath, you can't go forward with the policy or with the claim without giving the examination under oath. So it's kind of a double-edged
that's
sword.
not necessarily true in all cases. I've had it happen so many times over the years because I specialized in insurance claims, insurance bad faith and failure to pay and all of those kinds of things. There's a case, goes back many, many years. Well, it goes back at least 40 years because I remember it when it came out. That says that you can stay the civil proceeding or the claim until the criminal case has been resolved. Because
Absolutely.
otherwise the insurance companies become the surrogates for the police department.
Sure, and
they get what they can't get normally. They get it out of the civil case.
Right. And
so
that's
I get a stay.
And that's what they did in Blake. But I'm saying
Is that what they did? What did they do in
That's what
Blake?
they did in Blake. They stayed the civil case. The civil case was filed actually before the criminal case was filed.
Okay. Because I think the folks that are listening to the show and who are going to listen to your show are interested in the real life experiences because that's what makes the show fun, as opposed to my just dialoguing and fooling around with questions from Gary, who he asks me very good softball questions. We prepare for that.
I don't prepare at all, just to let you know.
You're Mr. Extemporaneous. You know, you really are.
Thank
Mr.
you.
Extemporaneous.
Whatever that means. Thank you.
But you know, it's very interesting. I'm going to give you a little compliment, Gary. We played the Roger Stone interview from last week for a lot of people because I was really very pleased with the way that came out. I really liked it. And a number of people said, you know what? The guy that works with you, I'm seeing Gary, he's great. He got more attention than Stone did.
Stop.
No, everybody
Whatever.
likes you, Gary. You know, it makes the show so much better.
Thank you, Judge.
So, bottom line, tell us, Scott,
What can I tell you?
about some of these cases, your personal experiences.
Robert Blake and come on.
Robert Blake. Robert Blake is
He's not guilty,
not
right?
my favorite.
Not his favorite person,
He's
right?
He's not guilty of pulling the trigger. I can assure you of that. He's not my favorite person. He's a bad, miserable little man.
Is he still around?
Yeah, I guess. I don't know. He's not calling me. I assure you of that.
Well, you helped him. You got him. You got him not
I
guilty.
did, but he wasn't guilty. He didn't pull the trigger. There was a hung on one of the charges, the solicitation. That was a hung jury, but they're not going to go back and retry the entire melee. But he didn't pull the trigger. He wasn't guilty of that.
Is that the only charge that was against him?
Criminal, he had, the actual murder, pulling the trigger, the actual murder. And then he had I think a single solicitation charge, and that was actually hung. They could not come to a decision on that. And so basically they wanted the murder, so they walked away.
Well, you know, there's the old felony murder rule. Somebody else could have pulled it if you participated in. It's like a conspiracy.
Sure, but he's already been tried for it.
Oh, no, it's not going to be retried.
So he
sure.
can't be retried for it, right?
No,
that's double jeopardy, right?
Yeah.
That's what I want to talk about in this hypothetical, not so hypothetical. When we talk about circumstantial evidence, I'm going to talk about this great case before we finish today because I've been thinking about it.
Okay.
And you'd be surprised the twists and turns that cases sometimes take. We got a not guilty on that case, and the guy had 2 prior felonies. Of course, the jury never knew that. I would never put this guy on the stand in 2 million years. And you had a better chance of getting a dinosaur than getting him on that stand. But the fact of the matter is the jury made a mistake. They found him not guilty because they didn't know there was such a thing called a hung jury. There was 7-5 for conviction, and he walked. I'm going to talk about that in a little bit.
Okay, cool. It
right
is
after the break.
For the people with Judge Herb Dodell.
And if you have any questions,
ask Judge Herb.
Contact me. askjudgeherb@gmail.com. And I'll do the very best I can to answer them. I've been pretty good so far.
You're damn good at it.
Well, I try to pay attention to the people's questions.
You don't answer mine, though. All right, we'll be back after this.
NBC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Okay, I was just mentioning that sometimes jurors, any jury in total, make a mistake. In fact, what's really interesting about this case, and I don't think I've ever mentioned it to anybody, after the verdict came in as a not guilty, and the judge was about to discharge my client, you have the right, either party has the right to do what they call poll the jury. Polling the jury means that you ask each juror individually. The judge asks each juror individually, is this your verdict? And if you count the 12 people and they're not all in favor of one or the other, then it's a hung jury. And the jury made a mistake. They couldn't come up with it because the numbers didn't meet the requirements. So you were just telling me, Scott, about the Rampart case.
Right.
It goes back a while now. It's probably about 20 years.
Yeah, I guess late 90s. Yeah.
Yeah, a long time ago. I remember the case.
Yeah, LAPD Rampart case. And what happened was there was an issue as to whether or not an accident took place between two police officers and a motor vehicle. And this gentleman, Raul Munoz, wow, it's coming back to me. Raul Munoz was arrested for this accident, and the computer spit out 245A1, which is assault with a deadly weapon.
GBI?
And then it put out GB with W/GBI, with great bodily injury. Well, the problem is the computer is putting out, and it's not actually, if you read the statute, it's clearly not with great bodily injury. It's likely to produce great bodily injury. So if you hit somebody with a car, even though there's no injury, it's still likely to produce great bodily injury. But that's not what the computer spewed out on a police report. You know, there's only so much room they can put in there. That being said, so the jurors, when I went out and interviewed them one at a time, indicated to me, and they gave me declarations, and that's what caused Jackie Connor, Judge Connor, who I think is still in Santa Monica.
I think she retired.
Did she? Great judge. She was wonderful.
Nice person, too.
Yeah, very sweet. But Judge Connor realized that the question was very simple. Did the accident take place, yes or no? As far as the charges, the allegations, anything else doesn't matter. And again, the jurors were never, they even sent back a question. As you know, jurors will ask questions. And they said, what constitutes great bodily injury? And her response was, it doesn't matter, move on. Because the question remained, did the accident happen, yes or no? That's all you needed to decide. And if the accident happened, then again, a vehicle is likely to produce, plain and simple.
That lawyer should have done a better job.
It wasn't something that you can perceive that is going to take place. It's not something that you sort of think in advance that the jury's going to come back and want to understand what constitutes GBI, because again, you're so involved in this case at the time, you know that the accident happened, and that's all you're focusing on. As far as the rest of there's no way to predict juries. There's no way to see what they're going to focus on.
I've said that many times in my book. I always recommend settlement, because you don't know what that jury is going to do on any given day, and they will make mistakes. We had a case that they just didn't want to deliberate. It was a 3-day weekend coming up. One was going on vacation the following week. They were done. There were 150 exhibits. They weren't going to spend the time to read them. And so they did the most expedient thing to do. It's a pox on both of your houses, and everybody goes home. And that happens too. That's why you need to seriously consider settlement of any case. There's no case too good, and there's no case too bad. I mean, the chances are on both sides, but it's a matter of degree. You don't gamble when you have that kind of thing that's hanging out. And by the way, if that DA, his name was Jim, if that DA had polled the jury and the judge had heard there was 7-5 for guilty, he'd have sent up, probably would have been a mistrial by that time, because everything was out, you know, and you probably
can't poll them until they come back.
You can't send them back in, but it certainly would have been a different verdict than a not guilty. It probably would have declared a mistrial. And for those of you who are out there, a mistrial means you start all over again. Sometimes either the parties or the lawyers do something that's really not correctable. The lawyer says something or tries to introduce documents that they know is not admissible, things of that nature. Judges will declare a mistrial, and you start all over again. And that's not double jeopardy, by the way, because there's no finding. You can't have double jeopardy until there's been a decision made on a particular count.
Well, unless you have a situation of a prosecutorial misconduct. If the DA does something or law enforcement does something and the judge dismisses it based on that. But simply having a hung jury, no, it doesn't automatically.
No, you get to do it over again.
I had, speaking of polling, I had a murder case that was actually tried 3 times, and in the second trial, the judge refused to poll the jury. And they had returned the jury verdicts, and they had made a mistake. They didn't sign a not guilty on the first. The charge was a first degree. Then they were given, of course, what are called lesser included. I'll let you explain that. Of a second and an involuntary. And they didn't sign the verdict forms indicating not guilty on the first, and the judge read the verdict forms. And of course, at that point, the judge, who's, again, very nice man, I don't really know what that was all about. I've been in front of him a million times, and the judge flat out refused to poll the jury.
I don't think
declared a mistrial.
I'm not so sure that wouldn't be error.
Oh.
But it's too late. Once you do that, it's too late. You got to start over anyway. Because
and they did, and he was convicted the third trial, but he had a completely separate attorney who was not prepared and had no business being involved.
That happens too. Lesser included, by the way, since you mentioned it. You take a burglary, for example. You can charge a burglary, You can charge trespassing. You can charge a whole bunch of things that are lesser. You could be charged with a felony,
Grand theft.
and then you end up with the potential. The jury is given the potential, if the facts support it, the evidence supports it, of finding a lesser and included, and someday they'll come back with a trespass, which is a misdemeanor. And
that's what I got.
And you know, but they let you out.
Well, they it could have been DUI, or not DUI, but drunk in public, or
well, you know,
instead it was trespass.
You know,
long story.
Kate, practicing trial work really requires making difficult decisions sometimes. You may not want a lesser included.
Right.
Because if you think you've got a strong case to beat the charge, the major charge, you may not want to entice the jury to compromise and pick out something which is a lesser
included.
Judge,
let me ask you a question. So do both parties, the prosecutor and the defense attorney, have a right to say, I just want the one charge, or
no, usually it's the defense.
It's the defense that asks for lesser charges.
Or they I think you have to be offered the opportunity.
That's what I was asking. Who makes the prosecutor makes the offer? Or
no, the judge basically will say to you,
makes the final decision.
You want to add a count, like on a murder case.
Right. That's what I'm asking.
There's a murder. There's a murder 2, and there's an involuntary manslaughter, right. and there's a voluntary manslaughter. Any one of the 4. If you're a defendant and you're facing a murder 1 with or without the possibility, the exaggeration, you may want to take a shot, hope that the jury's going to come back with an involuntary manslaughter, and you get a slap on the wrist, or you get a year, or whatever it turns out to be. Whether it's and just so you know, generally there are 3 options for the court. The court does the sentencing. The 3 options are high term, mid-term, and low term. High term might be 8 years, mid-term might be 6 years, and low term might be 4 years. And so you have to sit down with the client and say to yourself, okay, what do we want to take a shot at here? You know, if we get high term, or you're going to spend 8 years or whatever that number is. And you have to make a decision, and you better make sure your client understands it and you memorialize it. So if something goes south later on, they don't come back and say, well, if you had told me I could have only got 2 years, I would have taken it. They would have always taken it. But you got to be very, very careful. Sometimes the clients are your worst enemies.
Can I tell you something real quick? I had a judge, speaking of Torrance, I'll tell you his name off the air. I had a judge. We had a case. It was an attempted murder. And the judge created a whole new charge that doesn't even exist. And she was ultimately convicted of attempted voluntary manslaughter. You ever heard of that?
Attempted voluntary
what?
manslaughter. I don't think you can have that.
And he did, and she was sentenced to it. She was sentenced to the low term, 1.5 years. Where that came from, I don't know. She was sentenced to 1.5 years, but then she was sentenced to the high term for the use of a weapon. Basically, her boyfriend was beating her up, and she shot him. And so she got 10 years added on personal use,
wow.
11.5 total. And ultimately, that was commuted by the governor. It was removed by the governor. She ended up spending, I think, about 6 or 7 years in prison.
Wow.
Well, you know, we've talked about the way charges are filed. And when I first started out in the DA's office, one of the first things that I was assigned to was being a filing deputy. Filing deputy is the representative of the DA's office that interviews the police. They come in and they sit down and tell you why you should file whatever you should file. And a lot of times you will file high on charges because you're hoping you'll negotiate a settlement down the road where somebody will take something lesser and included, but you overcharge. And if you don't resolve it, you go to trial on those overcharges, and sometimes it affects your credibility.
Don't you feel bad about that, Judge? When you know that shouldn't be the actual sentence, that you're overcharging someone for a crime they committed?
But it is so common, and it's been done for so
long. Do you feel
long.
bad about it?
Doesn't make it okay.
Do you feel bad about it, Judge? That's what I'm asking.
I don't remember back that far.
Driving under the influence is common. Doesn't make it okay. But I have a question for you. Are you familiar with Scottish law? Also known as the bastard law. Okay. So in
bastards,
Scotland,
I know, but I don't know.
No. Don't be looking at me.
I'm not looking at you.
Scottish law, and by the way, this is a pet peeve of Harlan Braun. He's been trying to bring it back for years. And what they do in England is you have guilty, not guilty, and not proven. And the prosecution, the DA's offices won't do it here because that not proven has the same outcome, for lack of a better term, as a not guilty. But the problem with Scottish law is it gives the jury an out. Casey Anthony, classic example, O.J. Simpson, Robert Blake, all these people, it's not an issue if they didn't do it, they're guilty, not guilty, but the prosecution failed to prove their case. And they do that in England, but they will not do it here.
But you always argue it that the prosecution failed to prove their case, number one.
I understand that, but you're not giving the jury that option. So that's why they come back with the lesser included. Again, I just had a murder case. They came back with a second.
Maybe.
Simply because they knew something happened. Somebody died. But again, in Scottish law, they would have come back. Again, Casey Anthony is a classic example where they would have just come back and said, not proven.
Okay, if it's not proven, can they retry it?
No.
No, that's a finding.
Okay, I just was curious about that.
In fact, I always say to juries in criminal cases, when you look at the ballot, you look at the verdict form, it doesn't say anything on there about innocent. It says guilty and not guilty. And so you don't have to find them innocent. That's not the responsibility of the defendant. It's the responsibility of the prosecution to prove it beyond a reasonable doubt to a moral certainty.
And if you gave them that third option of not
that'd
proven,
be the same thing.
That would be the same thing. But it also gives the jury a way out of not convicting somebody.
That's true.
And that's why the prosecution absolutely in the United States will never, ever, ever do it. But they have that in England. Or the United Kingdom, I guess I should call it.
Well, the bottom line is most people think that by voting not guilty, they're finding the person innocent. And that's not true. It just means that the prosecution hasn't proved their case. In fact, I once asked a PD, public defender, how she was able to represent some of these people. And she says, I'm representing the system. All I'm saying is the prosecution has to prove its case beyond a reasonable doubt. And if they don't do that, it doesn't matter about the defendant. It's their obligation. That's the heart of our system. And so it's not about being proven not guilty. They just didn't prove that the person was guilty.
Sure, I believe
that's the way it works.
I believe I'm defending the Constitution. The police have to follow the laws. They have to follow the rules. And if they don't do it, it's up to me to exploit the fact that they didn't do it.
It's the same thing with suppressing evidence, which we can talk about too.
Mm-hmm.
Okay,
I guess we'll do the other case that I was talking about next week.
We got plenty.
If you really want to know about the case, and it really was interesting, really interesting.
Let's do it on your YouTube channel.
We can't do it in 3 minutes.
Sure we can. All right, it is. I was going to say my show is for the people. We got to
KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
There you go. Whenever a word comes up that has legal connotation, I kind of anticipate the public is saying, what is that? So I try to address it. And you mentioned, we were talking about aggravated circumstances in the case in Torrance, the attempted voluntary. I mean, that makes zero sense. But the word really is called an enhancement. Mm-hmm. Now, you take a murder case, first-degree murder case. People always say, well, why is it that they got charged with first-degree murder and the DA is looking for the death penalty? And in other cases, the DA is looking for what they call life without parole, LWOP, life without potential of parole. And an enhancement is added on, like the use of a gun in a particular crime adds time to the sentence if there's a finding of guilty. Now, in a first-degree murder case, there are certain requirements in order to get a death penalty determination. lying in wait, multiple people were killed. There's a variety. It's all listed in the penal code. And that is talk about bargaining chips. Many people will plead to the murder one without possibility of parole, as opposed to taking the shot at maybe getting the death penalty. And that's one big gamble that people are taking, and that's on the table most of the time when you have really bad cases. Somebody really did horrible things, and they're a real candidate, for death row, and they'll cop out because they know they're not going to win anything. That's what's probably going to happen to the guy in Florida, the guy that killed all the students at Parkland. There's no way he's going to win that case.
How can he?
He can't. Well, you can.
How?
It's a defense that rarely works, and that is mental issues.
Okay.
I have found over the years,
like David Chapman with a.
Well, I suppose. Yeah, I suppose. The fact of the matter is, first of all, in some states they don't even have death penalty cases. But if you can prove that you were so mentally unstable you don't understand the difference between right and wrong, and it's called the McNaughton rule. McNaughton, McNaughton rule. And that says if you can't tell the difference between right and wrong, you can't be tried. You end up in a state hospital, but you can't be tried for any crime because you don't have the mental capacity to commit the crime. Now, there usually are two elements in a crime. One is called the actus reus, and the other is called the mens rea. Those are the two general terms that are used. The actus reus is the actual act. The mens rea is the intent. And you have to have certain crimes require an intent. A burglary doesn't require an intent. You broke in the house and whatever it is, that's actus reus. And so if you're addressing what's called the mens rea, you want to be able to show that that person either was mistaken or didn't know, and you attack the intent part of the allegations. And under the right circumstances, and I'm not saying it works all the time, if you're able to present that in a way, it's an affirmative defense, of course, but if you present it in the right way, you may be able to get a reduction in whatever the elements of the crime are, and that's your perfect example of a lesser included. You can argue, if you choose to do that, for the lesser included. I've done that before too. You go up to say, look, they can't prove A because it's missing certain elements. But all it really is B. And even B doesn't work because of, and then you pitch your whatever you do. You have to remember that in a criminal prosecution, the prosecutor goes first. And you've got to really be able to address what comes out of the prosecutor's mouth, because that's your only shot, and if you don't raise it then, you didn't raise it. And one of the most important things for anybody who is going to law school or wants to be a lawyer or a litigator is it's called the record. If you don't make a record objecting to certain things, asking for certain things, objecting to jury instructions, suggesting instructions that the court doesn't give, whatever, you must make a record. That's why there's a court reporter. In criminal cases, there's a court reporter. And the reality is, if you don't make a record and you take it up on appeal with some minor exceptions, you're married to the record that exists. And if you didn't raise it below, you're not going to get to raise it above. And I've seen horrible miscarriages because the lawyer was sleeping. Not literally, but sometimes maybe even literally. I've seen some of those. I look like we told the story about the drunk judge on the case we had here. This guy was sleeping.
He was drunk.
He was drunk. By 1:30, he was whacked. He came back from lunch. He drank his lunch for sure.
Where was he sitting? What court?
He was lying down. Where was he sitting?
Well, I mean, whatever, Judge.
It was in Riverside.
Riverside.
Yeah.
Okay.
He was a real bad drunk too, but the bottom line is
he's a nice guy.
He really wasn't.
Okay.
And but he was friends with the people in the system. When we went to the Court of Appeals, They had known him when he was an assemblyman or something like that. They all knew each other, and they were very unhappy that we were raising this and impugning this guy's character as a drunk. And look, the A people liked it. The reality is that you got to make that record. If you don't make that record, I believe it's malpractice. Not that I'm encouraging people to do that, because legal malpractice is one of the most difficult cases to win, because you have to prove what's called a case within a case. You have to prove that if the lawyer had done A, B, and C, the result would have been different. You got to retry the underlying case. And that's pretty hard to do sometimes, because you now have a record. Criminal case, you have a record. In a civil case, maybe there was a court reporter, maybe not. If there's no court reporter, the judges hate that, by the way. Without a court reporter in civil case, the judges hate that, because they have to now write a statement of facts and findings. That's work. It's hard work. And they have to take the pad that they've been writing on and doodling, whatever, and make something out of it and write something that both parties will agree that could be used as a record on appeal.
Do you doodle on the stand, Judge? I mean, on the
I
bench?
never have the time.
You don't have the time to
No.
doodle on the bench? No.
Never.
There was a judge out of Malibu when it was open who would sit on eBay all day on his computer, and you could see it.
Really?
You talking about John?
Yeah.
He was a good guy, John.
Absolutely.
I liked him very much.
Absolutely. That's not the point.
But the guy that took over for him is going to be a guest on the show here one day.
Oh, is he?
Larry Myra.
Oh.
Great judge. One of the nicest, most decent guys, caring, sensitive, thorough, great guy, Larry Myra.
Okay.
So now I want to play the show for him so he knows that I said good things about him. I ran into him at a deli recently, and I said, we miss you, you know. What happened is they closed the Malibu courthouse.
Oh, did they close it finally?
And he said, I'm not traveling. I'm not going to go into all those cases went to Santa Monica.
Oh, really?
Some of them went to Van Nuys.
Oh, wow.
Really?
And so, he says, I'm done. He's retired. And
there used to be a courthouse in Calabasas, people.
Yeah.
Yes, a little courthouse up the road there.
Mm-hmm.
I used to go there with my dad. My dad used to have a lot of trials in Calabasas and the Malibu courthouse. I used to go to Malibu courthouse all the time.
Malibu was great. The little courthouse in Calabasas was a little dive. It was it's the size of this room.
But from an investigative standpoint, I used to be able to just jump over there instead of going through all the nonsense at Van Nuys or even Chatsworth, and I could go get docket sheets from them because they were still tied in. So
What's a docket sheet? What's a docket sheet? Just so you know what the term means.
I don't know, what is it, Judge?
He's going to tell you.
Docket sheet is in any particular cause of action, whether it's criminal or civil, they maintain a record of all of the documents that have been filed or rulings by the court or dates of appearances, whether or not somebody's in custody in a criminal case, the defendant is present in court out of custody kind of thing. And it's just obtaining a record, and you can get a certified copy of a docket sheet that we use sometimes instead of a certified copy of the complaint when you're doing something to indicate that it came up in Cosby. I mean, again, I can go on all day, but in Cosby, there was an issue that Robert Shapiro had sued Janice Dickinson, and she denied it, and we had a certified copy of the docket sheet that I had obtained from the courthouse. So, but she still denied it, said it didn't happen. Okay.
Rob Shapiro and I were DAs together. In fact, we ended up working for the same guy. His name was Harry Weiss. You remember Harry Weiss? He was on Sunset Boulevard. He handled a lot of the Sunset Boulevard traffic. The hookers, I think I mentioned it. I was doing that for a while. I represented all these streetwalkers.
Yeah.
They were great. They were
B girls, 647B, B girls. B girls.
Yes, 647B.
I miss
as
those
opposed to 647F, which were
drunk in
drunks.
public.
We throw these numbers around like they mean something.
Right.
Yeah, it's a 402. I'm gonna have a 402 hearing.
I know what a 420 is.
My friend Tony in Seattle won't even talk to me anymore because I got to go deal with some 1108, and
well, you have an 1101 issue in the Cosby case.
1108 in Cosby. Yeah.
I don't do much. I don't sit on criminal cases. So my experience has been over the years that I was a defense lawyer, and I handled probably 50 jury trials as a criminal defense lawyer, and they're much more fun because there's very much less paper.
See, and I really don't do civil. That's sort of my problem, is that 99.9% of everything I've done through the years, last 30 of 39 have been nothing but criminal, almost exclusively.
They're easier. Criminal cases are easier because in civil cases you have tons and tons of paper. and motions and everything. In the criminal cases, it's generally go in and do it. You know,
Yeah,
you have some documents, of course,
Yeah,
and you have witnesses
factor.
issues, and you have make motions like I was going to mention today. Maybe we'll talk about it if we run out of time today. Motions to suppress. People say, what is a motion to suppress? A motion to suppress means that certain evidence that exists, usually written evidence, was obtained unconstitutionally. I told a story about the big robbery in Santa Ana that I defended one of the two defendants, and they were dumb. They wrote to each other and put something very inculpatory in it, like one of the customers that came in to get her gold, he was storing gold, her name was Christmas, and she came in to get her gold, and of course it was gone by then. These guys had spent it in Truth or Consequences, New Mexico, digging for lead or something, whatever they were doing. The bottom line was, it said Christmas came early. And they thought they were kidding with each other, right? But when the cops busted him and they searched his car, there it was. And so I made a motion to suppress. It was granted, and it was never got into evidence. So that's it for today. This has been fun today, Gary.
Great show, and look forward to hearing Scott Ross, All Things PI, debuting here on KCAA 9 a.m. June 21st, Thursday, June 21st, 9 a.m.
June 21st.
All Things PI with Scott Ross, and great show. I loved it, Judge. Did you enjoy it?
Yeah, I did. I always enjoy the shows. My wife says it's a hobby. This is my hobby.
Whatever. Is it all? You like it, don't you?
I do. I think that we help the people. That's what this is all about, telling people what it's all about so that they don't deal with the uncertainties and the fears and the anxieties that they get when they're in a system that they don't understand. We try to make it more understandable.
And you do a great job at it.
Oh, thank you.
All right. Scott, look forward to your show.
I do too. Thank you.
All right, cool.
I'm
For the
excited.
people with Judge Herb Dodell, if you want to get his book, From the Trench to the Bench, go to Amazon.com. If you want to ask the judge a question, email him, askjudgeherb@gmail.com. Judge will be back next week. Right, Judge?
Yes, indeed.
Knock on wood. All right.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
So, you want to be in show business. Do people tell you that you're really funny, you have a great personality?